Good afternoon and welcome to Licensing Subcommittee. I'm just going to read out some points from the protocol for remote hearings. Only speak when invited to by the chair. If you wish to speak, please raise your hand and direct all communications via the chair. Please ensure that your mics are muted when you are not speaking. When speaking, be succinct and do not exceed the allocated time frames highlighted. If you're referring to a specific page or picture in the report, refer to the page number. If you're having technical difficulties, please use the chat function in the Google Meet to alert the meeting of any problems. Please do not use the chat function for putting formal questions to the subcommittee. Any persistent disruptive behaviour will result in removal from the meeting. Decisions of the subcommittee will be circulated within 5 days, working days. Please could I ask the subcommittee to appoint a chair?
Could I nominate James Peters, please?
Seconded.
Thank you. So if everyone has the pack of documents in front of them, you'll see that on the second page there is an order of business. We only have one item for this meeting, which is the premises license at U725, I think that's some typos in it, Orsman Road, N1 5FB. The first item, however, is welcome, which I think we've largely done, but I think it might be helpful for us to just go around the virtual room here so that everyone can identify themselves. My name is James Peters. I'm a councillor in de Beauvoir Ward. If I could pass on to Councillor Pluvier.
Hello, everyone. I'm Councillor Pluvier from London Fields Ward.
Councillor Peter Snell from Dalston Ward.
Mr. Gray.
Peter Gray, Governance Officer, Hackney Council.
Thank you very much. Ms. Sriramani?
Yes, Sriramana. Right, I'm Subhash Sriramana, Principal Licensing Officer.
Thank you. Ms. North?
Hello, I'm Amanda North from Legal Services, solicitor supporting members this afternoon. Thank you.
Thank you. Mr. Riviere?
I'm Channing Riviere, Principal Licensing Officer.
Thank you. Georgia Lazari?
Good afternoon. I'm from Legal Services. I'm just observing this afternoon.
Yeah, thank you. And Mario, you're providing the IT support. Mr. Dadds, I understand that you're here for the applicant.
Yes, I am. Good afternoon, members. I'm David Dadds, and I have the applicant on a separate device sitting virtually next to me.
Okay, and we have Ms. Mohammed, who is also observing from the legal department of the council.
Yes, good afternoon, everyone.
Okay, so then the next item on the order of business is apologies for absence.
There are no apologies for absence.
Wonderful, and then declarations of interest from the members. No,
None.
not from me either. The next item is item number 5, and it says licensing subcommittee hearing procedure. I couldn't actually see this in the document. Is it in the agenda? Is it there somewhere?
Should be, Chair. Sorry.
I mean, it doesn't really matter unless Mr. Dadds is particularly animated by this.
No, I'm not, and I'm used to the procedure here. You can prompt me as we go along if you want, Mr. Chairman.
Wonderful. In which case, I think Mr. Gray, are you introducing the application from U7?
Sorry, councillors. I present the report.
Oh, sorry. Yes.
Thank you, Chair. Licensing Service received an application for a premises license under Section 70 of the Licensing Act 2003 for Unit 7, 224 Osman Road for the hours stated in the agenda. Only licensing authority representation remains. However, since publishing the agenda, I have noted in the report, Para 2 under current status history is incorrect. The premises is licensed as the holder has appealed the decision to revoke to magistrate. I have a copy of the premises license, which I can circulate or share on the screen if required. I have nothing else to add. Thank you, Chair.
Yeah, sorry, so this is this is paragraph 2.
Yes, paragraph
And then
2 under the current stated history.
It says that the premises are not currently licensed for any activity, but we're saying that that's incorrect because the revoked license is subject to appeal, so it continues while that appeal is pending. Is that right?
That's right. So if
Okay.
required, I can circulate the license document to the members.
I don't think we need that, do we? No, there's heads shaking here, so thank you.
Thank you.
In which case, I'll move on to, unless anyone has any queries on what we just heard? Any need for clarification? No? Okay. In which case, Mr. Dadds, if you could tell us about this application. You have, I think, about 5 minutes. If you could constrain yourself to that time, then we would be very grateful.
Yes, thank you. Can you see me, Mr. Chairman? Because I can't see myself on the screen.
Yes, we can, yes. Well, I can.
Okay, great. So, good afternoon. This is an application. In essence, the hours and the licensable activities are analogous, similar to the license that's already existing on the premises. In essence, it's removal of condition 31. This is a new application, so actually my starting position is that the current license and the current appeal are not relevant to today. Today we're dealing with this application on its own merits and in accordance with statutory guidance under section 1.17. Each application should be judged on its own merits. Members will be aware that this application has been made and there are no representations from the police service, nor are there any representations from environmental health. And in fact, you'll see on your agenda and the paragraph 3, it says environmental health protection, no representation, environmental health enforcement, no representations. The police, there were a couple of conditions asked for in relation to no glass and drinking vessels outside, smokers limited to 5 at the rear, and those police conditions can be seen in their letter to the licensing authority and the removal standard times. There have been no members of the public representation, and that, as I say, only one representation remains from the licensing authority. The policy position is that I would say that you would look at primary evidence that the licensing authority wish to present. At the moment, there aren't any, so I'm sort of lacking on being able to respond because I've not seen any witness statements, any evidence regarding complaints or the complaints themselves, other than hearsay and representation made in a previous matter. And we do not know the maker of the letter or the statement. In relation to sources of advice, you'll be aware, Mr. Chairman, members, that you would look, for example, on crime and disorder as the police as the main source of advice, and they raise no objection. Equally, you rely on the environmental health pollution team and the enforcement for advice, and they make no representation either. I am aware that there were complaints historically regarding residents of noise transmission, and when we were before the licensing authority previously, they had confirmed there'd been no new complaints, and in fact there's been no representation from environmental health. So I think that is the justification, because we've done works. There are in relation to the DPS and the management competency, 2.5 and 4.39 of statutory guidance is that these are matters within the competence of the premise license holder, should be, but the police would have and could have objected to the designated premise supervisor or management if they so wish. They didn't. Under determination of application policy 9.12 of the statute guidance, each responsible authority has an expertise in their respective fields. You should be looking at those as the main source of advice, and that the licensing authority ought not to or should not be acting on behalf of other parties. So, for example, the licensing authority should not be acting on behalf of residents, environment, health, community groups. They should make representations in their own right, and that sets out 9.14. In addition to that, we should be really looking at focus on the matters of concern or causes of concern, and not going beyond that. I understand from conversations with the licensing authority that in essence they're looking at the track record regarding compliance of condition 31 on the old license, and as I said, this is a new application. Food ancillary to alcohol has not been sought. It never was originally. The police and I have had discussions that ought not to have been on the original license. They agree to a variation, but that was dismissed. But in relation to this application, new application, they have not objected. They didn't object to it being removed last time. They certainly don't object to this license at all. And in relation to, we've done soundproofing works. I don't believe the licensing authority are asking for alcohol to be ancillary to food in any event. In relation to the plan of the premises, which has been provided, as I understand from the licensing authority, and I think that's Appendix C, you will see, I think I sought clarification from the licensing authority. There's no objections from any of the residents across the way, across the water, the canal. There's no representations from any of the canal side studios, no representations from anyone above. And I think they say they have had concerns raised in the past about the outside of the front of the premises, possibly people smoking. So that's why we offer conditions that there's no smokers outside the front, and making sure that there's no drinking vessels or open containers taken out the front. So, as I say, I don't believe there's any, in recent times, any complaints. But as I say, it's for the responsible authority to adduce that primary evidence, which they have not done. In relation to the application, it's relatively straightforward. There is no track record of crime disorder. There's no issues arising, I would say, in relation to the operations of the premises, any material. And on that basis, environment, health, and the police have not objected. I ask that this application be granted because granted in its form, the operation will not undermine the licensing objectives. You'll note that we've got an outside area for consumption, for smoking, and with appropriate conditions. I hope that that's a brief summary of the application. Happy to answer any questions, Councillor Peters.
Thank you very much. I don't think I have any clarificatory questions at the moment, but Councillors Plivier and Snell may do.
Just procedurally, Mr. Dodds, excuse me, will it be possible for us to ask questions directly of your client?
No, because my client's on a different device. But if you ask me, I can ask my client, or I do have instructions. So obviously, I'm happy to answer any questions you may have.
Okay, so we can have answers in immediate time, as it were, through that way. Okay, thanks.
Good question, Emma. I have no questions at this stage. Thank you.
Okay, thank you. In which case, I think we want to hear from the responsible authorities, of which there is only one in the form of the licensing authority, as we've just heard. And Mr. Riviere, you are here for that authority, I understand.
Yes, thank you, Chair. So if you have a look at my representation with regards to this application, even though the applicant now is a limited company, it's still the same licensee as previously, where the license has been revoked. So primarily, the licensing authority's concerns are with the conduct of the premises and the management of the premises, and how this may possibly lead to undermining of the public nuisance licensing objective. Now, the licensing authority has been contacted by local residents raising their concerns about this premises, and you'll see in the section 182 guidance 9.14 that it is fine for the licensing authority to make representations should they feel necessary to do so if other authorities or residents have not made representations. So if we look at the track record that we've had with this licensee, they haven't complied with the license and they previously had their license revoked. So from our point of view, we haven't seen anything in their track record that suggests that granting a new license would mean that they would comply or act to alleviate some of the concerns of the residents. Now, I had a meeting with Mr. Dadds earlier in the week where he suggested maybe some conditions around the front of the premises and the exit, etc. And I spoke to the residents about this and they were still not happy with what was proposed. So from a licensing authority point of view, we would say that it's not right for the license to be granted given the track record of the licensee, the person who's going to be running this premises. It's not solely in relation to condition 31. The non-compliance with condition 31 was found by the licensing authority's own investigations into the premises. The primary complaints that the licensing authority received from residents are more to do with the noise and issues to do with the external area of the premises, predominantly the front external area. And the residents have raised concerns with us that they're still primarily concerned about that. So given that the committee revoked the license previously, it would be up to the committee to decide should a new license be granted on this premises. And I have nothing further to add at this stage, Chair.
Thank you very much. Councillor Snell and Pluvier, did you have any questions for Mr. Riviere? Councillor Snell?
Thank you, Channing. You've set out the legal grounds on which you feel you are able to represent local residents' concerns. But can I just ask, what you didn't really say was how many of them are you meeting? Have you had various on-site meetings with them to discuss the problems? How many have been involved? Can you just fill us out on that a bit?
Currently, Councillor, there are 2 residents who have outstanding concerns about the external area of the premises. And I have had contact with them via email and telephone.
And can you perhaps explain to us why they didn't make a formal objection?
Well, Chair, they've chosen to remain anonymous. So I'm not really at liberty to go into detail as to what their representations are. But they've chosen specifically to remain anonymous and asked us to raise their concerns to the committee.
And as I understand it, and Amanda can tell us about this, if they are anonymous, then we can't consider them. But what you're telling us is we can consider those concerns put into your report, and you have every legal right to give that report.
That's right. That's right.
That's correct, Councillor, yes.
And appended to your report, there is also there's a Companies House record, and there's also an email from Councillor Adams, who is the councillor for that area. That's right, is it?
Yes, Chair. The Companies House record is just to demonstrate that the director of the limited company applying for this license is the licensee of the license that was revoked. So in effect, we're still dealing with the same individuals operating the premises that raised concerns for the licensing authority and local residents. And the email from Councillor Adams is just to demonstrate that there are concerns from local residents around the operation of this premises and how it's conducted.
Okay, I think Mr. Dadds might have a legal point here. Is that right?
Yes, I do.
And what is it? Sorry.
Mr. Chairman, and I know your legal advisor is listening, I do raise objections to Mr. Revere making reference to the two residents, because one, under the statutory guidance, and the law, the 9.37 says you focus on the matters specifically raised in the representation. They may not add further in those to those already disclosed prior to the hearing. So in other words, the two residents referring to now have not been disclosed to us, the applicant, prior to this hearing. In addition to that, there's no reference to those two residents in the original representation. And I did say to Mr. Revere on Monday, if he wishes to rely on the two residents, and I'm not too sure if it was one dwelling or two dwellings, he would have to put that information before me, before the hearing. So it's not that I'm trying to stop him today. I told him that on Monday. I was told additional information may be laid. I checked today with Democratic Support, and they said no further information will be laid. And I said, well, if there is any new information at the hearing, I would say that is not acceptable. It's against the guidance and the law and should not be relied on. In relation to the position of the representation made within the report and the email from Councillor Adams, I will refer to that perhaps in the questioning, but you will note that that email relates to the review and not an email relating to this application. Councillor Adams did not make representations, or any member of the public or councillor, regarding this application, which must be dealt with on its own merits.
Okay, thank you very much.
So I just wanted to raise that as the legal point for the moment, and it is incumbent upon the licensing authority to provide its primary evidence. So a copy of the complaint, a copy of the investigation of complaint, so that you've got that track record, that information before you, rather than just a mere assertion without the primary evidence being laid and given before us, to give me a fair opportunity to respond.
Okay, thank you. To be fair to Mr. Riviere, he was answering a question from Councillor Snell, but Ms. North, could you advise us on whether we should be taking into account Mr. Riviere's response to Councillor Snell?
Mr. Riviere's response was for clarification. Was it a point of clarification, Mr. Riviere?
Yes, it was for clarification, but if I can just allude to the Home Office guidance section 9.14, which does specify at the end of the paragraph, however, if these parties have failed to take action and the licensing authority is aware of relevant grounds to make a representation, it may choose to act in its capacity as a responsible authority. So I would contend that we are allowed to make reference to what we have experienced in our own representation in dealing with this application.
Within 28 days and prior to the hearing.
Yes, I was just going to say, as long as you've given notice of it and in that 28-day period, that only on that basis should it then be put forward for consideration as a representation. You can't obviously bring in additional representations at a late stage after that 28 days, because that wouldn't be acceptable as a relevant representation.
So I think that the legal position is that we shouldn't be taking into account that response to Councillor Snell. But Councillor Snell, you had something there.
I'm at a bit of a loss on what the fuss is, to be honest. I mean, we've got very clear evidence laid before us in the correspondence from the local councillor. I was just interested in the basis of what he was saying. I mean, I'm not quite honestly. I mean, I'm losing your arguments a bit, Mr. Dadds. The problem I have is that evidence has been out there for a long time. All I was trying to clarify where it might have come from. But it's been out, when the committee papers came out originally. And I also don't understand the point that you're making that somehow it refers only to the review. Because surely it applies to the way that the premises operate when people, when it's used as a drinking establishment instead of being used as a restaurant establishment, which is what we originally licensed it for. So I don't understand why you're somehow arguing we can't consider all of that. It seems perfectly relevant to me.
So, Mr. Daz, if you could hold on, Mr. Daz, if you could hold on there for 1 minute. So I think that now we're essentially moving into the discussion part of the meeting, and I think that there are 2 points that I would very much appreciate Mr. Daz's input on, and there may be others from others. And the first one touches on what Councillor Snell just said, which is well, actually, first of all, I think we need to put to bed Mr. Rivier's response to Councillor Snell, and that's something that I think the advice is that we shouldn't be taking into account. What I don't think that means is that we can't take into account what we see in front of us in the papers that had been circulated previously, and specifically about the evidence that we see in Councillor Adams's email. Councillor Adams is representing the people in his in his ward, and he was democratically elected to do so. And Mr. Daz, I think this connects back to something that you said, which is that there is no history of antisocial behaviour on these premises. Now, that does look to me like antisocial behaviour from these premises. Could I ask you to address that point? And if you think that what Councillor Snell asked something differently, something different, then if you could address that point at the same time, please.
Yes, thank you, Mr. Chairman, and I'm grateful to Councillor Snell for setting out his question and asking the relevance and seeking clarification, because at least then gives me an opportunity to respond. The point I'm making is that this is a new application, and with a new application, you have to treat it on its own merits. And the statutory framework that regulates the decision making says you make an application, you get 28 days to advertise it, which we've done in the newspaper and a public notice, and then anyone wishing to make representation must make representation in that time. So that was the point I was making about the 2 residents referred to that not made representation, and that I did give the Mr. Riviera, with fairness to him, on Monday an opportunity to put in further information if he wanted to, because the guidance is clear that you should allow the applicant to have an opportunity to respond, and then it's fairness of the process. So I haven't tried to exclude residents, but I'm also trying to uphold a process that is fair and just. So, and in relation to what we have been served within 28 days is in the pack, and of course you can have reference to it, but in relation to the 2 documents relied on by the licensing authority, one I believe from a resident or one from the councillor, I say this: even though you have it, you have to determine what weight you place upon it. And what I am saying is that that representation was made in relation to other proceedings. It wasn't made in relation to this application. That's the first point. Secondly, even though it was made at that time, Councillor Adams did not come to the committee, I don't believe, to stand behind that representation to be asked questions. So second point. Third point, from a legal perspective, there's a case called East Gwent Magistrates Court. It's a High Court decision that says if a maker of a statement is not present at a licensing committee to ask questions of clarification, what weight you attach to it is a matter for you, but it's probably likely to be little or no weight, because clearly the councillor's not here. He's not made representation in relation to this application. It was relating to another. In addition, it's hearsay that he's making on behalf of another resident that's making it, who is not present. So the weight you attach to that representation is little or no weight, because the maker of the statement is not here. The maker of the statement didn't make it in relation to this application, and the maker of the statement made it based on hearsay made by another person that's not here either. So what I'm trying to draw to is that Councillor Snell said we have clear evidence. Well, actually, you have a document that has little or no probative weight in case law or in fact. And the East Gwent guides you to that determination. And that's why I said, well, look, the licensing authority have had notice of this application. The council has its own systems in place, and I know that there's been some difficulty with the IT. I accept that, and that's why I've been upfront saying, what records do you have? What can you draw to? Tell me in advance. But it's for the licensing authority to provide to you and to me in advance the primary evidence they wish to rely on. So where's the complaint history? How many residents? What was the date? How did they complain? What were they complaining about? What was it investigated? Was it corroborated? Because all those questions are normal questions to try to understand that its probative value of the evidence of the complaint. Because someone makes a complaint doesn't mean that it's has a connection to us, whether the duration, the time, when it happened. Look, as I understand it, Councillor Peters, the complaint that the two residents, whether they're one dwelling or not, as I understand it, relates solely to the outside front door. And that's why we put in conditions, and I've offered to the licensing authority any additional conditions regarding that particular concern.
So do you mean the door onto Ormsman Road?
Yes, that's right. And that's why I put the condition, because the police and I had discussion about it, putting condition about no drinks outside, no smokers outside. So we push it to the rear and that we have, in effect, our own area there. So I understand, obviously, there are other matters going on, but we have to separate those from our minds and look at the evidence that you have here. And that's the statutory framework. So everyone got 28 days. Councillor Hadams didn't make representation. No one else. We're just dealing with a licensing authority who have not put in any witness statements, any council database logs, any complaints, none of the primary evidence for which I, in advance, would have an opportunity to respond to be fair. So I hope I've answered those points that you asked me to clarify, and I'm sorry if I went on a bit further.
Well, no, that's very helpful. So I'm not sure that I actually understand this point about this is made in relation to a separate application, because this seems to go to the management of the premises. So I do think that it is relevant to this application here. I'd be appreciated if Ms. North might talk to this East Gwent point.
I haven't got the case to hand. I'm going to have to look it up and come back to you.
Okay, well, in which case, Mr. Riviere, could I also ask you to tell us about why there isn't any evidence as to the records of complaints made to the licensing authority that Mr. Dadds points out?
Well, Chair, during the period of this application, you'll be aware that there was lockdowns across the UK. So insofar as the premises has not been operating, there wouldn't be a reason for residents to make complaints. And regarding the emails that we received, because they've chosen to remain anonymous, then unfortunately they can't be included. So the context of my representation is mainly to do with the licensing services experience of dealing with the licensee on this premises, and that's what we have based our representation on. A lot of it would be weighted in the revoked application, the application for review which revoked the license, which Mr. Dadds is aware of, and that's been our experience. Now, unfortunately for the applicant, because of the lockdowns, they haven't had an opportunity to demonstrate if they've changed their behaviour or not. So all we have at the moment is their track record, which unfortunately led to the revocation of their premises licence, which they've subsequently appealed.
So I mean, the evidence that we've got in front of us from Councillor Adams is not just relevant because it relates to the premises, but it's additionally relevant because during the period between that evidence being sent in and now, the premises hasn't been open, right? So it is effectively contemporaneous evidence, right?
As far as I'm aware, it hasn't been operating due to the lockdowns.
Okay, thank you. Mr. Daz, I'll come back to you in a second see if Ms. North has something to add yet.
I'm just emailing the case to
Right.
the solicitor.
Great, thank you.
Okay. Is that what you were going to say, Mr. Daz?
No, I wasn't. Just a very short point, if you'll allow me, in response to Channing's point, is that you will ask rightfully, where's the complaint history for when it was operating, and why haven't you disclosed that to you? And that has not been disclosed. We all know that there's been national lockdown of various types since last March. So as I understand it, and in fairness to Mr. Riviera, the point that I think he makes is that the council licensing authority found that the premise license holder and the applicant, in essence, because it's through the company, and we've been quite open with that, was in breach of a condition 31. But we explained that then that police were happy for that to be removed, so that addressed the issue. There were some issues around that condition, but what I would say is that this application is on its own merits, and there's not a condition ancillary. He says that part of his objection is based on the revocation of the license, but remember, as you've been told, the license is still valid. It's not been revoked. There's a decision to revoke which has been suspended, and there is an appeal. The premise license holder of that license is of the opinion that the local authority's decision is wrong, and that's their right to have that opinion, and there's no disrespect to those councillors that sat on that decision. That's their right to say that they believe it's right, and it's for us to be able to appeal. But I don't want to be tied up with that decision, because that decision is undecided. It needs to go to the court, and it needs to be determined.
I don't want to cut across you, but I think that is a point that we don't need to discuss, because I think that the panel accepts that is not something that is relevant to this application.
Okay.
And it seems to Councillor Snell nod and Councillor Pluvier as well, I think, yes. I'm sorry, I've had Councillor Snell with his hand up for a little while, so I'd like to bring him in. But one thing I'd say before I do that is that I said earlier that I had two things that I wanted us to clarify and to discuss. One was the status of Councillor Adams's email. The other point was something that he said, Mr. Daz, was that there was no contemporaneous or more recent issues, but there does seem to be, and that is the failure to comply with Condition 31. Whether or not Condition 31 should be there, whether or not this application that you're making contains that sort of condition seems to me somewhat by the by, because there is evidence here of a failure to comply with the condition. The content of that condition seems less relevant to me. The fact that the applicant has failed to comply with it appears to be relevant. So if you can just hold that thought for a moment, I'll bring in Councillor Snell.
Thank you, Chair. Mine's a bit separate, but we might as well get them both down together. I'm struggling a bit. I always struggle when I don't have paper copies of these agendas, and we've had problems with the print room and COVID infections at the town hall. So I'm doing my best with this, but looking through it online, I don't find any reference to the provision of food whatsoever. Now, clearly we have various standards, and I may just be wrong, so correct me if I'm wrong, but we have various standards for the provision of food. I mean, one of them is rather than substantial meal must be served, is along the lines of, you know, that substantial food must be available at all times. I just wanted to get a feel, and you say that you've got the licensee available to brief you on this. We haven't so far had a feel for what you're trying to do. I mean, this does appear to be an attempt just to set up a stand-up bar, a heavy drinking establishment, and not much else. So can perhaps the applicant just explain what the concept is you're after here? Is it just to pack as many people in as possible and let them drink, you know, within the fairly generous conditions that you've set out?
And by a canal that acts like a sandbox. Mr. Daz, if you could answer those points, please.
Yes, thank you very much. I will deal with the first point about condition 31. I think you're right that there has been discussion around whether the premise license holder has breached the condition, and there was test purchasing exercise, and alcohol was purchased without having food. But as I say, the licensee's view was that they could have a drink prior, and there's a sale, and they would sit down and consume food. So there was some discussion around that. The local authority have never and have not prosecuted that point, and the statutory guidance is clear that someone is in, you know, that the innocence or guilt of an individual is not a matter for the licensing authority, and that's a matter for the court. There's no suggestion that breach or alleged breach undermined the licensing objectives. So no one is suggesting that a breach of condition 31 undermined the licensing objectives. Now, you may not be with me, but I argued last time, and Councillor is here, that the police have not raised any objection, the environmental health have not raised any objection, and that I say the main and primary concern last time from the licensing authority was that condition. Obviously, that has been removed. Now, so that Councillor Snell has a bit more of a background around this application, is that it was always asked for as a bar. It's very attractive premises. It has a limit of capacity of 95. There's adequate and ample seating. Food is provided, and predominantly it is largely a lot of seating. It's not vertical drinking establishment. Pack them as high as you can and encourage that. I mean, remember, the police would object, Councillor Snell, if they thought that we would be doing that and undermine the licensing objectives. So would environmental health. So it's not that. And we did show some nice photos last time, but unfortunately I don't have any here, but I could probably get them to you. It shows the interior. It's a very high standard and quality. The seating and furnitures and fixture and fittings are superb. So it is a nice environment. And of course, the capacity is limited. The conditions are quite robust. And we are going to be providing food. But as a way of background, what happened is that the original application made it very clear this is what it intended to do. And on the day of the hearing, the police asked for a number of conditions. And buried in with those conditions, there was one, I think, condition number 14 that said alcohol should be ancillary to food. My client, unrepresented, thought that meant, in effect, you have to offer food. And so that condition was accepted. But clearly, it's not a restaurant. And therefore, after that, it became quite difficult for them to operate the business. But what they would do is sell the alcohol, a pre-drink, and then offer the menu. Then you would order food, and then you'd have a drink afterwards. But it was proving very difficult for them to operate in that way. They should have been and should have applied for a variation then and there at the time. They didn't. We did apply for a variation during the review process because I gave advice. There was no objection from Environment Health or the police or any resident, as I understand, if I recall, or no one appeared. And that was rejected. But it's all been focused on, well, we're not varying a license which we've heard for a review. They heard the review first and felt that they couldn't necessarily deal with the review. So this is why new applications come in, because you have to deal with this on its own merits. And it's about the licensing objectives. I'm saying the police are with us, the environmental health, no residents, no Councillor Adams. This license is the same hours as it currently is licensed, except for we're removing and adding conditions which tighten up the front, the use of the beer garden, and removing condition 31. So now condition 31 removed, they will not, there's no other suggestion of any other breach other than that one condition. And in relation to the management, Mr. Chairman, Councillor Peters, there was criticism of the premise license holder, and we accepted that criticism where it lay. And what we did is said, we will change the DPS. So in advance, we've done that. We've changed the DPS, and the police are happy. So there has been, in effect, some sanction, and there's been substantial cost in going through this process. The premise license holder does want to promote the licensing objectives, and I think we recognise by changing the DPS, there's a recognition that to improve on the offering in the sense of its management. But that's it. I think that's where we are on it. I'm happy to answer any other questions. Now, I don't know if this will work, but I've got the client here on WhatsApp. I could unmic it and see if you can hear her make any comment, any additional comment, if you'd like me to try.
So before you do that, can I just, you say that there's a capacity of 90, or we say there's a capacity of 95.
Yes.
That is there a separate capacity for the external areas?
No, that's combined, Councillor Peters. It's combined inside and out.
So, and the part that runs sort of perpendicular to Ormsman Road towards the canal and then gives out onto that patio part, jutting out onto the canal, that's a courtyard, is it?
Could you give me your page number, please?
Yeah, sure. It's on the PDF that I'm looking at. It's 31 of 41. It's the proposed plan.
Yes, one moment. I have got it here, but I just need to find it. See, I've got paper. Here we are.
Yeah.
So, could you repeat your question for me? Now I have the plan.
Yeah. So there's clearly an internal area that runs parallel to Ormsman Road.
Yes.
But then, if you would face that from Ormsman Road, on the left there is a portion that moves towards the canal, and there's the bit that's running towards the canal, and then there's the bit that's jutting out onto the canal. The bit that's jutting out onto the canal is external. Is that right?
It's all external. That with those benches outside. Can I just? I don't know if you can see my camera and me pointing, but this here is external, and there's a restriction of use after 9 o'clock.
And before 9 o'clock, there's no capacity restriction, is there?
No, there isn't. No. So at before 9, it's there in that area. You can see the tables and that small area there. No objection from here. No objection from anyone here. No objection from anyone across.
So no use of that area after 9. Are you saying?
Except for limited to no more than 5 smokers, because otherwise it could potentially go to the front of the premises, and that's why we're moving the smokers there and limit it to 5 as agreed with the police. Okay, so which condition is that? That's condition, I think it's 21, but let me just have a look at my notes. The rear outside the premises should not be used off. Yes. Yeah. Condition. I think I've got condition 22, condition 36, and I think those are the conditions regarding the outside. Let me just check. Yeah, condition 17 to read: the rear outside shall not be used after 2100 hours. It's safe for a maximum of 5 smokers. Yeah. Condition 36 is that there should be no glass, drinks, or open containers taken out the front of the premises. And I believe condition 22, if my memory serves me right, limits the. Let me just look at that. It's not 22. I think it may be in your report as 22, but it says 17, no more than 5 smokers outside at one time.
Okay.
Yes, I think those are the restrictions that are placed on the rear and the front.
Okay, thank you very much. I think just, I see that Councillor Snell wants to come in. I think Councillor Pluvier, you also wanted to come in, did you? So, Mr. Dowds, before we take you up on your offer of allowing the applicant to speak sort of through that setup you have there, I'll ask Councillor Pluvier to come in.
It was to ask the licensee, seeing as she or he, I don't know. I thought it was originally she and now he, but I think you said she at the moment. Is that right? I'm sorry.
Yes, what's your question, Councillor?
I want to ask her, because I think she will remember the original hearing, what she understood to be the rationale behind the introduction of condition 31, the meals condition, how she understood what the reasons were for that at the time.
Yes, okay, so should we hear from her now? Should we try it?
Yes, that would be really useful, thank you.
Did you, so I apologise, I've got to speak here. Did you hear that from the councillor? I did, yes. Right, I'm going to try to turn up the volume so you can be heard. 1 minute. Right, speak as loudly as you can, and I think the microphone's there, so it should pick you up. Try now. Okay, hello? Yes, carry on.
Can you hear me?
Yes.
That's it. Now give your answer, please, regarding the rationale behind the original condition and your thoughts.
So my original understanding of condition 31, that we needed to serve substantial food within the premises, to have that option of having substantial food. So we created an industrial kitchen, so created a substantial menu with starters, mains, desserts, and all sorts. So that was my understanding, that we had to provide food. Not a longer drink, but as well as.
Sorry, my question wasn't what it meant in literal terms. It was, why did the hearing put that condition on? What was the reason in the hearing for that condition to be put on?
Madam, sorry, so that you both know, it was actually put on before the hearing. It was an agreed condition with the police that they made a representation in the afternoon and said, if you agree to, I think, 18 conditions, and this was one of them at 14, we would withdraw our reps, and that's how it came about.
Okay, that's all right. Well, if I'll accept that as the answer from you then, Mr. Dowds. It's obvious that you have a good understanding of it.
Yes, I read those papers.
You could give us your understanding of what usually lies behind the some of the reasons why there might be a condition like that.
Well, generally, I believe it's because it can be cumulative impact. It can be so that.
What do you mean by cumulative impact in this sense?
No, not in this sense. No, I'm just saying one of the rationales sometimes can be that, but I'm not saying here because there is no cumulative impact. Right. My understanding from the officer, and I had the conversation with the Metropolitan Police about it and asked them what was the rationale why, because I'd seen the application, I'd read it, I'd read the representation from the police, and there was no evidence to support the request for that condition. The Metropolitan Police accepted that position, and
sorry, I did ask you about generally. I mean, the reason that I ask is that generally along the canal, these premises have that condition in order for them to be quiet, because most of this is not the only premise like this along the canal. There are quite a number that were built like this. They have residents above and all around. And as I think Councillor Peters said, the canal acts as a funnel for noise. So I think all of them have the meal condition, and the reason it's there is that they are predominantly restaurants, so that people don't get loud and drunk. Yeah. I'm now answering the question for you. I was hoping you might put some of that in, because that would have, to my mind, would explain why that condition was on there, but maybe it doesn't to you or to the applicant.
Well, it certainly, I think, in fairness, I was trying to answer the question that, based on the evidence and my conversation with Metropolitan Police, there was no rationale why the condition was there in the first place that I can see or evidence. However, I understand the point that you make, but my client is prepared to offer food, substantial food, as an offering, but not that it should be ancillary to the taking of a drink. So we're happy to offer food, because we do. That is part of our offering. So we do sell food, and we want to sell food. But in relation to the canal, I understand those concerns, and that's why it's limited in its use an hour. Environmental Health would be equally aware of that. And we've advertised it twice now on 2 occasions, the last and this, with the last variation and this one, and no resident above or opposite has actually raised any objection. So I think we can manage it, and we will manage it. And obviously, with the conditions, I believe we can promote the licensing objective. So if you want to have a condition that says the premises shall offer food, that is not objected to, but not the alcohol ancillary too.
No, I only wanted to know if the premises license holder had understood the context of the original condition, which is, as you say, the main reason for having this license.
Yes.
So I've got hands up from Councillor Snell and Mr. Riviere. Mr. Riviere, do you have something to add to the discussion that we're having here?
Yeah, all I was going to add was in response to Mr. Dadd's comment earlier, when he was speaking specifically about condition 31. The review application was not made solely on the basis of condition 31, although that was a substantial part of it. It also included reference to the complaints from local residents, and given the fact that the licensee was also invited to a PACE interview and had ample opportunity to change the license condition and seek to change it rather than sort of willfully breach it as we would see it. So this is why it gives us concerns as a licensee operating over the track record of the licensee with regards to this application.
Yes. So I think what we're being asked to do is grant a license in circumstances in which we do have some evidence in front of us of public nuisance being caused by the operation of this premises by the applicant, and there's evidence of non-compliance with the conditions of a previous license. Councillor Snell, did you want to come
in? Thank you. I don't think I'm even more confused now. I don't think Mr. Dadd's addressed. He wants to get rid of the condition that requires a substantial meal. I said I could not see another condition in the new application that talks about the next step down, which is we will make sure there is food available to customers at all times. Now, as I say, I'm slightly struggling doing this online rather than having a paper copy in front of me. But now David has said to us, oh yes, but we're very happy to add that. Now, either we've got a food condition or we haven't got a food condition. So far, we've understood it was complete removal of the food condition. Now, David Dadd seems to be saying, oh, you know, you can put a food commitment, but not the substantial meal one. So can we just have clarification on that? And can we have a suggestion of exactly, I mean, if the condition's in there, sorry if I've missed it, but if we were minded to approve this on that basis, we would need to know what the applicant was suggesting.
So I think the suggestion is that we add in that condition. It doesn't exist at the moment, but Mr. Dadd can enlighten us.
Can I just respond, Mr. Chairman, to your comments that you just made, a summary? I don't wish to be disrespectful, and I hope that you won't take it that way, but you summarise saying we have evidence of non-compliance, we have of a condition, and we have evidence of some nuisance. But I'd ask you also to say that you also have evidence of the police not objecting, environmental health, no residents, and that the evidence you do have, you have to look at the weight, because I'm challenging that weight because it's hearsay and it's not before you. I know that you probably meant to say it that way, but it could just be saying that you're only looking at the negatives and not actually also the positive side, which weighs it up as a decision. I know it's not just a black and white decision, it's a decision in its rounds, but I'd like you to...
Absolutely, we do have evidence. The weight of that evidence you've challenged, and Ms. North was going to speak to us on that when she is ready to do so, which may be now.
And in relation to Councillor Snell's point about the food, let me make myself absolutely clear. The application was just to completely remove the condition that was never wasn't offered in the original application, but was put on by the police. We removed it, and we are offering food, but I wasn't planning to put that on as a condition. I didn't think it was necessary. But if it allays the concern about the canal, and that you would like to see a condition as members saying that food will be available, that's completely different to a condition that says alcohol is ancillary to food. But I, on behalf of the applicant, will not object to your standard condition that says that a substantial meal will be available. And I'm just looking at your standard conditions, and I'll see if I can work out which one it is, and then I can suggest that. So as a point of clarification, we're content because we are offering food and we're not changing that, but we just don't want it being a condition that alcohol must be ancillary.
Just one other point on the evidence in front of us. We don't have a representation from Environmental Health, and we don't have a representation from the police. So we have neither a positive representation or a negative representation. Are you saying that the lack of representation should be taken as positive endorsement of this application?
Yes, because the case of Daniel Thwaite, where the High Court decision says that the committee have to have regard, because the police would be the main source of advice. Here, they have engaged with us. There's been a representation. There's been negotiation. There's been clarification and an additional condition. That must be positive, that the police, being the expertise in their relevant field of crime disorder, they have no objection. Therefore, it has great weight that you have to have regard that the police are satisfied. So it's not because we've not heard. It could be either or. It's actually a positive, and it goes in the favour of the applicant. And that's
so Ms. North, thank you very much. Ms. North might be able to come in on that and on this East Gwent case.
Yes. Yes. Basically, the East Gwent case was the decision there was where the justices had refused to admit evidence from the local residents of some rowdy, which resulted in rowdy behaviour in the neighbouring public house, and it was held that the justices were wrong to refuse that information being considered, but they'd erred in refusing to admit the statements, and the application was allowed. So basically, you can, it is at your discretion to adduce the evidence that's before you, and to take into consideration the weight to be attached to it. The fact
there was a little or no point that was being made by Mr. Dadds. I don't know if we can have a paragraph when you're on mute.
Yes, and that came from Patterson's licensing law that said that you have to take into account hearsay or where the maker of the statement is not present, but what weight you attach will be a matter for you. But in Patterson it says it will be little or no weight because the maker of the statement is not present.
So East Gwent says the court said you can take this into account, and you're saying that the authorities there that you cite.
Yes, what he's quoted is correct. That is correct. Yes.
Okay. Okay.
It's just clarifying the point of that you can have evidence, and you say we've got evidence here. It's clearly there, but then you have to then look at its weight, why it was made. And all the points I made earlier on, it relates to another application, but it's still there. The maker of the statement could have made another one today in relation to this application, turned up and spoke to it, giving us a fair opportunity to comment. I hope that is. And in relation to your standard conditions, it's G15. Oops, apologies. It's G15.
Thank you.
Councillor Peters, what Mr. Dadds has said about the attaching the weight to the evidence, that is correct, and it is a matter for you to consider. But I think the fact is that because the actual representations, there's no opportunity for cross-examination or for anyone to ask questions of the parties. That's where the concern is as to the weight that you're attaching to it, because they're not here to give live evidence.
And they weren't made in relation to actually this application.
Is that a point that it comes from that commentary you have, Mr. Dadds, or is that your own gloss?
No, it comes from that commentary, but in relation to weight, if it's even further hearsay, if the comment was made in relation to another application, not this one, it just makes it further removed and the weight even less.
Albeit it's about the operation of these premises by the same applicant in circumstances in which these premises haven't been operating between then and now.
Yes, that's absolutely correct. But as I say, equally correct is that the make of the statement is not present, doesn't make it in relation to this, and that can't be challenged or tested, because I can't ask questions of clarification, nor can you.
Yes.
Right. I think the issue is that the fact that they haven't made the statement, reiterated their comments for this particular application, and that's the concern. I think Mr. Dadds has.
Yes, well, I mean, we can't know why that hasn't happened.
No,
Mr. Riviere, did you have your hand up?
Chair, I already spoke by comment when my hand was up earlier.
So if you could take it down, I'd be grateful. So I think we're probably close to or at the end of the discussion phase of this hearing. Looking at Councillor Snell, yep. Councillor Cloutier, yep. Okay. So in which case we move to closing statements. Mr. Riviere, did you have anything that you wanted to add? You don't have to.
Chair, I would just reiterate what I've said. Our representation is based on our experience with this licensee and this premises, and the disturbance that's been made to local residents. It's the primary reason that we have concerns about this application. If you look at the track record that we've experienced, it's not only the non-compliance, it's also the nuisance complaints. And given that we haven't had any opportunity to observe changes in behaviour, we would be very wary of overturning the decision of the committee prior to this hearing, which was to remove the licence for the same licensee. So it's at the discretion of the committee whether they grant the licence or not. But our position is that it should be refused or at least deferred until such time that the review hearing appeal can be determined.
Okay, so I think that we're not taking into account, and we shouldn't take into account, the fact of the review, that we have evidence here, and the weight that we should attach that evidence has been discussed here. We have evidence here that form the basis of that review, and that evidence we may or may not take into account in our deliberations here. Mr. Dadds, do you want to sum up as well?
Yes, please. I'm just going to take a few minutes just to summarise. As I said earlier on, that each application must be judged on its own merits. Each responsible authority will have an expertise in their respective field, and those will be your main source of advice in their expertise. The police and the Environment Health have not made representations in relation to this application. There's been no residents making representation or councillors. In relation to the licensing authority, they're not expected to act as a responsible authority on behalf of other parties, i.e. local residents, and that's 9.14. That doesn't mean that they can't, but I would respectfully say that if they do, then they need to provide the primary evidence of the logs, the complaints. So I raised earlier on when, where, who, what, how, why. and none of those details in primary evidence has been provided. It's vague. In relation to its operation previously, if they had the evidence, they could have provided it in advance. In relation to the focus, we've looked at condition 31, and I hope I've addressed that, and you've heard from the applicant. And I would say that operationally, there's no evidence before you in this application of an undermining licensing objective from the responsible authorities, from the police or environmental health. I am acutely aware that there's been the review, but as you say, you're not taking that into account because that's subject to an appeal, and that will be heard on its own merits as and when appropriate. I believe the issue regarding compliance can be addressed and has been addressed by a new DPS. The police did not object using their powers under the guidance of 4.39. They did not object to the DPS, and that has been before you now. I have set out the conditions regarding managing the outside. That seems to be the main concern that two residents, which you're not taking into account, but nevertheless we've heard it, and that's why I've put in place the conditions to address the concerns regarding those two residents historically, but those two residents to deal with those issues arising. In relation to the food offering, I've dealt with that and offered the condition G15, substantial food should be available at all times, along with the additional 36 conditions regarding the operation of this premises. The hours are akin to what is already licensed. There's no evidence of fights, disorder, crime, any noise nuisance from the responsible authorities. All we have is the what you've heard, and I believe that has been addressed by this license, this application, which must be judged on its own merits. What weight you attach to the representations which are attached to licensing authority, I say little or no weight, because the makers of the statements are not present. The makers of the statement made the representations in relation to another application. I do accept they've been made in relation to this premises. However, it hasn't been corroborated. It hasn't been investigated, as I understand, or certainly no information has been put before you about the credibility or the validity of those matters which were complained of. They could be vexatious, they could be without merit, they could be substantiated, they could be mixed, we don't know. And that's why I say, in fairness to the applicant, they should have little or no weight, and that's what Patterson's licensing law in the commentary say, because the maker of statements are not here. As I say, it should be regarded using the Daniel Thwaite principle, that your main source of advice on those responsible authorities with that appropriate competence and expertise have not raised an objection, and they would be duty bound to raise objections if they felt the licensing objectives would be undermined. On that basis, and with the submissions I make, I ask you to grant the application as amended today, unless I can assist you further, that is the submission on behalf of the applicant. I think he's oiling.
Yes. Quite. Thank you very much. So unless we have any other need for clarification, no, I think we will probably need to retire and discuss, in which case we will come back to you with our deliberations shortly, or rather the licensing officers will do so. Thank you very much for your assistance this afternoon.
Do we wait here, or
no? If you could log off, and we will stop recording, and then we will deliberate, and then I guess we'll email you. Is that how this works?
The decision is communicated within 5 working days, or that's the minimum that we've given. Yeah.
Thank you very much for that. So good afternoon. Thank you, councillors, officers, and good day.
Thank you.
Okay.